The gun owners of America is fighting back against the ATF and Merrick Garland over a big attorney fee dispute as to whether or not the gun owners of America and their affiliates in the federal district court in Michigan are entitled to their attorney's fees against the ATF for the ATF's games in trying to defend the absurd bump stock ban. Let's break down how the gun owners of America is fighting back against the ATF's effort to stiff them and their lawyers in this major case. Let's break it down when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the recent law review article in the Georgetown Journal of Law and Public Policy, Dangerous but Not Unusual, Mistakes Commonly Made by Courts in Post-Bruin Litigation. Check out a copy of that article in the link to this video down below. It's totally free from the Georgetown School of Law in the Georgetown Journal of Law and Public Policy. Check it out, a 65-page analysis, lots of scholarship, lots of history, lots of explanation of some of the things we talk about on this channel about why the Second Amendment should prevail in all the modern gun control controversies in the courts. Check it out. All right, folks, so we covered this about a week or two ago. Gun owners of America, as you know, brought a major lawsuit against the Department of Justice, ATF, and Merrick Garland, challenging the bump stock ban, which ultimately was successful in the Michael Cargill case against the ATF before the U.S. Supreme Court, where the U.S. Supreme Court said that ATF lacked the authority under the federal statutes defining machine guns to declare a bump stock a machine gun, as defined by that federal statute. Well, after that win, the gun owners of America and other affiliates filed a motion for attorney's fees to which they are entitled, according to them, under the Equal Access to Justice Act, a federal law. They filed this motion in the United States District Court for the Western District of Michigan. The ATF, as we reported a week or so ago, came back and said that the gun owners of America are entitled to no money at all, zero, nada, zilch. And to the extent they're entitled to any money, they're only entitled to something like $120 an hour, something like that. Well, it turns out that the gun owners of America have decided to have another say at this, and they filed a request to submit a brief arguing that the ATF's argument is wrong. Specifically, that the ATF position, as articulated all the way up to the U.S. Supreme Court, was not substantially justified, and therefore the gun owners of America and their lawyers are entitled to their attorney's fees. They point out specifically that in addition to the fact that the legal position taken by the ATF was unsupported by federal law, as acknowledged and found by the U.S. Supreme Court itself, a lot of the factual assertions that the ATF and the Department of Justice under Joe Biden were making were just flat out false, and they were caught. They got their hand caught in the cookie jar, if you will. This is what the gun owners of America argue in this reply brief in support of their attorney's fees under the Equal Access to Justice Act. ATF not only was wrong on the law, but also misled courts on the facts. Much of the government's argument revolves around the fact that some courts, including this court, found ATF's position reasonable and or have upheld the rule or voted in dissent to uphold the rule. But it is not the law that an agency's position is substantially justified any time a court agrees with it. Indeed, the government defendants later admit that the substantial justification analysis under the Equal Access to Justice Act turns on whether defendants adopted a reasonable position, not the court. It is hardly surprising that some courts would reach erroneous conclusions when misled on the basic facts, when deferring to an agency that claims unqualified expertise in the field. Wow, that's powerful assertions by the gun owners of America attacking the ATF, saying not only did they get the law wrong, but they totally screwed up and misled the courts about the underlying facts of the case involving how bump stocks worked, how machine guns work, and so on. Specifically, the gun owners of America go forth and lay out exactly the factual arguments, the factual mistakes, or the factual intentional omissions or intentional misstatements by the ATF in the bump stock litigation. This is what the gun owners of America argues. ATF repeatedly represented to this court that bump stocks harness the recoil energy when a shot is fired, a flatly erroneous factual assertion that plaintiffs disputed. But as the U.S. Supreme Court explained, it is the shooter who uses a firearm's recoil to help rapidly manipulate the trigger. Similarly, ATF claimed that a bump stock shooter applies constant forward pressure to the firearm, another assertion on which this court again relied. But again, the U.S. Supreme Court explained this is not how bump stocks work. Bump firing is a balancing act. The shooter must maintain enough forward pressure, but not too much forward pressure, and thus must seek the right balance. Finally, defendants, meaning the government, asserted that a bump stock operates automatically because it sets off a firing sequence which continues without additional physical manipulation of the trigger. But again, the court made clear that bump firing requires ongoing manual input, without which a firearm will not fire multiple shots, citing to the United States Supreme Court decision in Cargill versus Garland. Well, that's a pretty powerful list of facts that the ATF allegedly screwed up. In other words, what Gun Owners of America is doing is very smart. They're saying in the federal district court here, these are the factual assertions the ATF made about how bump stocks work and why, therefore, they're machine guns, according to the ATF. But then those factual assertions were tested against what the U.S. Supreme Court found in terms of how bump stocks work, not just factually, but also under the law. And the Gun Owners of America here has pointed out that this just goes to show you that the only reason, or a major reason, if not the only reason, why a lot of other judges ruled in favor of the ATF is potentially because the ATF was misleading them factually about how bump stocks work. And because they were factually misled, the legal conclusions from those courts, or by those courts in favor of the ATF, was fatally flawed because they got the underlying facts wrong, and it required the U.S. Supreme Court to fix them. So then the Gun Owners of America, based on that, goes on to make the following argument, which I think is pretty good. These are not merely ultimately not correct legal interpretations of the statute, but instead are the government's misrepresenting the basic facts of how these mechanical objects operate. But the government defendant's opposition entirely fails to engage on the issue of ATF's repeated misrepresentations of key factual issues, misrepresentations which permeated this case's preliminary posture. Yet it is axiomatic that to be substantially justified, an agency must have a reasonable basis in both law and in fact. But as explained above, no reasonable factual basis exists here. Rather, the opposite is true, because the ATF repeatedly misinformed the court as to the basic operation of bump stocks. So as you can see, the Gun Owners of America has made a pretty compelling argument that the ATF's position in support of bump stock was not substantially justified, either as a matter of fact or as a matter of law. And therefore, the Gun Owners of America's attorneys should be able to be paid their attorney's fees by the government, by the federal government, using that statute, the Equal Access to Justice Act, to justify it. Now, I should also mention the last part of this brief is a fight with the federal government over the attorney fee, the hourly rate of the attorney's fees to be paid by the government if the court agrees that they should be paid. Again, under the standard rules of the Equal Access to Justice Act, I believe the hourly rate for an attorney is somewhere on the order of magnitude of $150 an hour, which I've pointed out in prior videos is really, really quite low in modern American life for quality attorneys. So with that said, this is what the Gun Owners of America has requested in terms of the hourly rate, at least with respect to preparing the documents associated with this attorney fee petition. Here's what they write in the final footnote of their submission by the Gun Owners of America. This is what they write. In addition to the amount sought in plaintiff's fee motion, the Second Amendment plaintiffs seek an additional $6,065 for the preparation of this reply brief and motion for leave to file. This total is comprised of 7.2 hours for Robert Olson at $425 an hour. 5.8 hours for Stephen Stromboulet at $425 an hour. And 1.8 hours for Carrie Morgan, Esquire, at $300 per hour. Now, let me be clear here. I have dealt with very large legal bills. Big time, bankruptcy cases. Okay. Let me just put those hourly rates, which I consider to be very, very reasonable for the quality of lawyering here. I want to just give you just 2 data points to consider this. These rates of between $300 an hour and $425. Eric Holder, the former Attorney General for Barack Obama, as of 2021, according to the public record, had an hourly rate of $2,295 an hour. Eric Holder. Now, a former Solicitor General, very good lawyer, Neil Katyal, okay, who's actually, I believe, an attorney for some of the anti-Second Amendment groups or the gun control groups, I believe, as I recall, on some justifying some gun control laws. Neil's hourly rate, as of a couple years ago, was $2,465, according to public reports. So I'm just giving you an example of Eric and Neil's hourly rates between basically $2,300 an hour and almost $2,500 an hour, and that was several years ago, versus the rate that these Second Amendment lawyers are looking for on an hourly basis between $300 an hour and $425 an hour, which just goes to show you really how reasonable these rates are, in the context of modern American life, modern American litigation. But again, just I thought that compare and contrast is sort of helpful for you to appreciate where these numbers come out. And as I've told you, if you are going to hire a Supreme Court law clerk who is leaving the Supreme Court today to come work for your law firm, you're probably looking at a signing bonus. And I'm not talking about salary. I'm not talking about Christmas bonus. I'm not talking about performance bonus. I'm talking about a signing bonus just for signing the deal and coming to join your firm as an associate is probably going to be somewhere in the order of magnitude of $400,000 today. That's about what I think a law clerk bonus is for signing with a firm, and that's on top of their salary and Christmas bonuses, holiday bonuses, performance bonuses, and the like, which are also going to be several $100,000 every year. So I'm just pointing out this data to kind of show you how really reasonable in the grand scheme, in my opinion, these hourly rates are. I've seen rates much higher than this, many, many years ago. Lawyers are not cheap, especially high quality ones. It's just the nature of the beast, supply and demand in the marketplace and all that good stuff. Nevertheless, that's where we are. So hopefully things work out for the gun owners of America. Hope they win this motion and get their money. I'm certainly cheering for them against the ATF and the Department of Justice. You would think if we can spend over $100 billion or whatever we spent giving money to the Ukraine, we can find money to give to attorneys that have vindicated our rights before the U.S. Supreme Court. Again, I don't write the laws and I don't make the laws, but it seems to me if we're willing to give all that money to foreign countries, we certainly should set aside some money for attorneys and people that are willing to vindicate our right to keep and bear arms across the country, especially against overreaching federal efforts that have unlimited budgets like the ATF and the Department of Justice with budgets in the billions, as in billions of dollars. Seems to be a small price to pay to vindicate our rights against these agencies, these behemoths. All right, so there you have it, folks. Hope you learned something here today. Make sure you subscribe to this channel. We're trying to get to 200,000 subscribers. Feel free to share this with your friends. Don't forget to follow me on Rumble because I'm now posting over there on Rumble because a lot of people like Rumble over YouTube, obviously. And make sure you check out my law review article. Don't forget to follow me on X at 4 Boxes Diner. And I look forward to seeing you all again real soon here at the 4 Boxes Diner.
Orders up. Table 2A.